Good afternoon and good morning to some of you. Thank you for joining Mayor Brown's webinar today. Our program will focus on Canada, U.S. cross-border travel, preparing for the legalization of marijuana in Canada. This is Grace Shee from Mayor Brown, and to begin, I will cover a few administrative items before we begin the webinar. First, at the bottom of your screen, you will notice there are multiple application widgets that you may use. All of the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presenters today. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. Time permitting, at the end of the program, we will allow for questions, although we do expect that we will likely use up the full half hour for today's webinar. Joining us today are members of Mayor Brown's Global Mobility and Migration Practice. I am Grace Shee. I'm a partner in the Washington office, and I am joined today by my partner, Paul Virtue, also in the DC office, and our associate, Emily England. Today, Canada's new law governing the legalization of marijuana goes into effect. As you might expect, this legalization by our northern neighbor has led to a multitude of questions that span many areas of law, including, for purposes of today's webinar, including cross-border travel into the United States. The United States, which continues to carry prohibitions under U.S. federal law. During our webinar, we will review the following. One, we will provide an overview of the relevant laws of both Canada and the United States governing this topic. Two, in an FAQ format, we will review questions that many clients and employers are now considering with respect to cross-border travel and sending their employees on travel to the United States. Finally, we will review application of the relevant laws and possible scenarios through some hypotheticals that we developed. And with that, Emily, why don't you walk us through the Canadian law that goes into effect today?
Thank you, Grace. So the relevant Canadian law for our discussion is the Cannabis Act. This law was passed in June of this year, June 2018, and goes into effect today, October 17th, 2018. The Cannabis Act provides the regulatory framework for controlling marijuana in Canada. And as of today, adults in Canada may legally purchase, possess, consume, and grow marijuana.
Thank you, Emily. Paul, why don't you walk us through the relevant U.S. laws that would impact cross-border travel?
Okay. Generally, an arriving alien who is determined to be a drug abuser or an addict, or who is convicted of or admits having committed or admits committing acts that constitute the essential elements of a violation of any law or regulation of a state, the United States, or a foreign country relating to controlled substances is inadmissible to the United States. If Customs and Border Protection, which regulates admission to the United States, if the officer has a reason to believe that the individual is a drug trafficker, for example, and a drug trafficker is somebody who is engaged in distribution of cannabis products, even a reason to believe the person is a drug trafficker may result in inadmissibility. So we have had media reports of even investors in marijuana businesses being turned around at the border. It seems that the latest advice from Customs and Border Protection is that unless the person is seeking admission to the United States to engage in business activities related to the cannabis business here, that the person is not likely to be questioned about their involvement outside the United States or investment, for example, in cannabis activity. The issue that we face here is that while some of the states, there have been 29 states and the District of Columbia have legalized medical marijuana. 9 states in the District of Columbia have legalized recreational marijuana for adults. But at the same time, U.S. federal law continues to make it a crime to possess, cultivate, distribute marijuana products. And so that's why we continue to have this tension in the United States.
Thank you, Paul. And with that, Emily, why don't you walk us through some of the frequently asked questions that we've received from some of our clients in addressing this issue?
Okay, the first question is for you, Grace, and we've been hearing this question a lot. Will travelers to the U.S. be asked at the border if they use or have used marijuana?
Sure. That is the most common question being raised by our clients now. Has there been some change in U.S. law or practice where all travelers should expect to be asked this express question every time they make a trip to the United States? And the answer right now is no. There's been no clear directive from U.S. Customs and Border Protection that they will include this particular line of questioning for all travelers, but we do all need to be on heightened alert that there is a very real possibility that questions relating to marijuana use, whether pre-legalization of marijuana use in Canada or post, may be asked. U.S. Customs and Border Protection is the U.S. agency that controls admission to the United States at the border and at ports of entry, so along our northern border. And CBP is required to determine whether someone asking to enter the United States is eligible to be admitted, as Paul defined earlier. And in order to make this type of determination, a CBP officer has broad authority under the law to ask questions of the traveler that may elicit information related to their eligibility for admission to the United States. I mentioned earlier CBP hasn't published a clear directive regarding this type of questioning, but I will call out that CBP issued a press release originally dated September 21st of this year that was then later updated on October 9th of 2018, and this press release is available on their website. And I will just read 2 relevant sections. U.S. Customs and Border Protection, I'm reading from the release, enforces the laws of the United States, and U.S. laws will not change following Canada's legalization of marijuana. That same press release later goes on to say, quote, determinations about admissibility and whether any regulatory or criminal enforcement is appropriate are made by a CBP officer based on the facts and circumstances known to the officer at the time. So that's quite broad. Could it be that a police dog that is sniffing a vehicle trying to cross a land border, if that sniffing dog alerts the CBP officer, that might be a factual circumstance that leads to a question. Could it be a bumper sticker on the vehicle? Could it be something in the systems that CBP refers to when making these determinations that indicates there might have been a prior violation in Canada pre-legalization? Any number of factors haven't necessarily been spelled out expressly by CBP, but does put everyone on alert that this very much could be a line of questioning.
Thank you, Grace. So, Paul, the next question is for you, and it's a 2-part question. If CBP asks a traveler about marijuana use, how should the person answer the question? And then secondly, can someone just refuse to answer questions?
I think first of all, in general terms, our advice to our clients is the same whether they're being asked about marijuana or any other issue at the border by a Customs and Border Protection officer, and that is to answer the question truthfully. Because answering a false statement to a federal officer is a criminal offense. A person could be subject to prosecution, but also misrepresentation to a federal officer is a ground of inadmissibility, and it essentially ends up being a permanent bar to the United States. There's a non-immigrant waiver, discretionary waiver available, but it's rarely granted. So I think the first answer is truthfully. But the other advice I think is well, it may go without saying, but I'll say it. A person should not show up at a port of entry and seek admission to the United States if they're under the influence of cannabis, or they're a heavy user of cannabis, and are going to have difficulty answering pretty straightforward questions. Customs and Border Protection has gone back and forth a bit, but it seems that their latest guidance is that they're not going to ask everyone about marijuana use, and unless they have a suspicion that the person is using marijuana, and one of the grounds of inadmissibility is if the person is likely to engage in criminal activity in the United States, and if an officer believes that a person might use marijuana in the United States, even in a state where it's lawful, it's still a violation of federal law, and so the officer could simply refuse that person's admission. And then the second part of your question, Emily, can they simply refuse to answer questions about marijuana use? Yes. A person can refuse to answer questions posed by the officer, but we have to remember that applicants for admission to the United States have the burden of proving that they're admissible to the United States. And so if they decline to answer questions, the result is likely to be that the person is going to be refused admission to the United States. And it's not always possible to withdraw one's application for admission. And so if a person is being declined for admission to the United States, that may become a part of their record. They can ask to withdraw their application for admission, but that's a discretionary grant by the officer.
Thanks, Paul. So the next question is again for you. If someone discloses marijuana use to a CBP officer at the border, what's going to happen? What are the consequences of that kind of disclosure?
Well, I think it breaks down a little bit and Grace has spoken to this a bit about the pre-legalization in Canada versus post-legalization. Customs and Border Protection seems to be picking up and are likely to make that distinction, whether the use was before marijuana was legalized in Canada versus after, and they'll make a judgment on that basis. It's possible that if a person discloses prior use, that they could be found to be a drug addict, for example, on medical grounds, or it just depends on the facts and circumstances. So we are going to have to wait and see a bit about this pre-legalization in Canada versus post-legalization. If the question relates to use in the United States and the person answers in the affirmative, then the same thing could happen because Customs and Border Protection is looking at use, cultivation, distribution as violations of federal law. So they'll have to weigh the consequences there.
Okay, back to you, Grace. Can someone travel from Canada to a U.S. state that has legalized recreational marijuana, such as Washington State, while in possession of marijuana?
Thanks. So that is a common question, or becoming a common question that's being raised when there's a bit of confusion sometimes by non-U.S. citizens, about the fact that certain states in the United States have legalized marijuana, like Washington State, the state of California. And questions have come up about direct travel from Canada, where marijuana has been legalized effective today, direct travel to a state where, a U.S. state where use of marijuana is legal. The answer remains the same, which is that cross-border travel, that cross-border admission is governed by U.S. federal law, and therefore the fact that the particular state, the destination for the traveler, even though the destination, the law of the destination state has legalized marijuana, the actual admission for the traveler into U.S. territory is governed by U.S. federal law, and therefore CBP determinations will remain just as Paul described.
Okay. So the next question is back over to you, Paul. How does the Canadian Cannabis Act affect travelers who are investors in the marijuana industry?
You know, Emily, it's not perfectly clear yet exactly how Customs and Border Protection is going to treat investors in marijuana businesses going forward. But it seems that based on the advice that Customs and Border Protection gave on 9th of October, that their focus on travelers whose only connection with the marijuana industry is as an investor is if the person is actually coming into the United States to be actively involved in the marijuana business. There have been, to date, and this is before the legalization, obviously, in Canada, media reports of investors being turned away at the border simply based on the fact that they are investors. And the connection there, what Customs and Border Protection is doing is essentially making a determination that the person is a drug trafficker because and all they have to have is a reason to believe. And so if their investment is in any way involved in, or the company they're invested in is any way involved in something that would be a violation of U.S. federal law, then they're looking at it as a violation of Controlled Substances Act. But they seem to be backing away from the turning people around the way the media reports had reported over the last, 3 months or so.
That's right, Paul, and I think it's worth our reading to the audience the relevant sections from the CBP press release that was updated on October 9th. And the release now says, a Canadian citizen working in or facilitating the proliferation of the legal marijuana industry in Canada, coming to the U.S. for reasons unrelated to the marijuana industry, will generally be admissible. That's the language used, generally be admissible to the United States. However, if a traveler is found to be coming to the United States for reasons related to the marijuana industry, they may be deemed inadmissible. And that's a direct quote from the CBP press release on this topic.
Thanks, Grace. So this final question is for you. What can employers do to best prepare for the implementation of the Cannabis Act, so today moving forward?
Sure. I think the most important, one of the most important things that you as an employer can do is to keep yourself apprised of new information and guidance as it becomes available. We have CBP's press release, their formal guidance on this topic. We do expect that probably with the passage of time, the legislation is so new as we actually see what happens at the border, as there are more situations that arise, and as CBP has to make such determinations that will likely lead to additional announcements, practice changes, practice updates that will be made available, if not through a press release or public dissemination, oftentimes in some press interviews. We have seen that leads within CBP are giving interviews and giving quotes to the media for various different types of publications on this specific subject. So some of this, frankly, is developing day by day. And one of the most important things is to simply keep yourself apprised, so that should an employee come to you with a concern, you're armed with information about the potential consequences of making affirmative disclosure at the border, and to the extent that we haven't mentioned very much about potential waivers of admissibility, but to the extent that you can arm yourself with information, that's the best way that you can protect yourselves right now.
Right, good. There is a waiver available for someone who has been convicted of or who admits the pertinent elements of a controlled substances offense, to the extent the person was convicted of simple possession of marijuana of 30 grams or less. And that waiver is available to someone for whom that offense occurred either 15 years ago and they have been rehabilitated and are not a danger to the United States, or the person is a Violence Against Women Act abused spouse, or the person can demonstrate extreme hardship to a U.S. citizen or permanent resident immediate family member. So the waivers are discretionary and only available under certain limited circumstances.
Right. And there's the general caution that to the extent you send employees to the United States on business travel, we do think it's advisable to allow for additional time, for additional screening, and for the cues that may develop, particularly, and this is our best guess, particularly for employees who may be traveling to a U.S. state that has legalized the recreational use of marijuana. That's not based on any particular press release or public statement by CBP, but I do think that it's fair to give that guidance to employees to the extent that they are planning for such trips and to allow themselves sufficient lead time. Thank you. And with that, Emily, will you walk us through a couple of hypotheticals that we've prepared for today's webinar?
Of course. So, Paul, let's say I have an employee who's flying from Toronto Pearson to Chicago for business meetings. If they used marijuana before today, before October 17th, are they inadmissible, and how would CBP even know?
Well, that's a good question. How would CBP know? They would likely... CBP does have a certain amount of information available to them on their screens at the port of entry related to criminal activity in the past. And so if a person has been convicted of a marijuana offense in the past, then Customs and Border, they have to assume that Customs and Border Protection would have that information available to them in their system. Or they may simply ask the person. And it seems, based on statements from CBP, both formal guidelines as well as responses to media inquiries, that they're not likely to ask that question of someone unless they suspect that they're using marijuana at the time or they smell marijuana. A lot of ports of entry, of course, people are driving through in their cars, so they might have the smell of marijuana in their cars if they've used it in the past. It seems that what CBP is going to do is to take a look at that individual and make a judgment, either whether they're likely to continue with that activity in the United States, which would make them inadmissible, or they may find that the person is, they believe the person is a drug addict, and they may require them to get a medical exam before they'll provide them with admission to the United States.
Thank you. So the next hypothetical, Grace, let's say my employee is driving from Vancouver to Seattle in the future. what's going to happen if he used marijuana after the implementation of the Cannabis Act?
Right. The purpose for this hypothetical, two particular facts that are different from the prior fact pattern. One, it's the date of use, which is post-legalization, and two, the destination in the United States is Washington State, which is the state that has legalized the use of recreational marijuana. And frankly, the answer again remains the same, that a traveler, the employee, should be prepared to answer questions that CBP may or may not raise about use of marijuana, including use of marijuana in Canada post-legalization. As Paul mentioned, CBP has responded to media inquiries and has given media interviews with respect to this topic. And I think what's noteworthy from some of the interviews that were, if not given yesterday, then were released yesterday by members of the press, the Executive Director of Admissibility and Passenger Programs for CBP is quoted as follows. And this is dated yesterday, if somebody admits to smoking marijuana frequently in Canada, then that will play into the officer's admissibility decision on whether they think on this specific trip they are also likely to engage in smoking marijuana in the United States. Because again, smoking marijuana in the United States is prohibited under federal law. He goes on to quote, it's based on whether the officer believes they may engage in the same cannabis-related activity while in the United States, based on the intent and purpose of their trip, as opposed to the legal engagement within Canada. So it all comes down to, again, sort of the same calculus, which is factors that may lead a CBP officer to ask questions about the use of marijuana to help them evaluate whether the traveler will indeed engage in the same activity in the United States that remains a criminal activity.
Okay, it looks like we have just a couple minutes left for this final hypothetical. So for this one, Paul, I have an employee who has told me that she's used marijuana illegally in the past, but that she's eligible for a waiver of a permanent bar, and she won't have any trouble entering the U.S.
Yeah.
Is that correct?
It may be, but first of all, I think the question is whether or not the person was convicted. If she was not convicted, then she's only going to be inadmissible if she admits to the elements of a violation in the past, and so the question is, whether CBP would get into that in an interview for a person's admission to the United States. Not likely, unless there's some current use of marijuana or more recent use of marijuana. But as mentioned earlier, the waiver, if she was convicted, for example, of possession of marijuana, and the amount of marijuana was either 30 grams or less, which is an ounce, basically, then that inadmissibility can be waived, and as I mentioned earlier, it can be waived if the offense took place 15 years ago or more. It can, as a matter of discretion. It can also be waived if it was a more recent offense, if the person can demonstrate extreme hardship to a U.S. citizen or permanent resident, immediate family member, a child, spouse, or parent, or the person is covered under the Violence Against Women Act as an abused spouse.
Okay. Thank you. We are at the half-hour mark. That wraps up today's program, and on behalf of Mayor Brandt, we thank you for your time. This concludes our webinar.